Anything mentioned not in the list? Any mentioning in the list? Item number one. Here are NDPS on of 125.
No, I appear for the petitioner hearing,
You got the CD.
Thought I got a CD.
Yes, what do you want?
What happened? I just placed in the.
Yes, yes.
What happened? 2% was found the possession of that whole video of kennel. During investigation, this petition was tagged under section 29 of NDPS because he was the arrest that used the supply. He used to bring from Kolkata, he used to supply to the person concerned. He is a permanent resident of the site. So charge sheet was filed after investigation against this person's petitioner. Absconding charge sheet happened. And in that period, he again brought 12 kg garlic from Kolkata.
not him. 4 kg.
Allow him
Yes.
this.
Then he was caught by the police in the airport. Then another case was registered. He is in judicial custody in connection of that case.
The next case.
Next case. During investigation, that was done.
Then he was remanded in the earlier case.
Yes, so what happened that on the strength of the production warrant, he is appearing before this case, before the trial. He was not arrested in this case. That is the fact of it.
When he was produced in this court, in this case.
7-10.
And in the other case, you have got the bail
Yes, already got bail.
in the second case.
He's already, bail was granted on 29-10-2024.
So in neither of the two cases, any recovery has been made from him.
Case section 29 is the supplier evidence is there.
Still, it is the quantity is intermediary quantity.
First.
And in the other case also, you said 12 kgs. So it is still less than commercial. It is still less than commercial. So which was the matter in which he was arrested?
That was FIR number 8 of 2024.
And then remanded in this matter.
Yes.
This is FIR.
This is FIR 36 of 2023.
That was
Okay,
the FIR
let us
6 June 2020.
Let's see the case. CD.
FIR 8 is a 6 June 2020.
The recovery is on 27/4.
Yes, my lord. In this
27.
case, yes, my lord. 27/4/2023
From two persons.
from 2 persons. They have already been granted bail.
Joint possession 4 kgs. Exactly 4 kgs.
4.077 grams. 4 kgs, 0.77 grams. The first lady accused, she was granted bail on 16/6/2023.
What is the present accused's name?
Harudas, my lord. Haru, Harudas.
That is from their house. So it is, his name is not.
No, his name is not,
Is not
he's not
FIR.
FIR named accused.
In investigation.
There was as a supplier.
At the time of filing charge sheet, his name was invoked.
No, they say that we have purchased it from
Loss.
somebody.
But during investigation, another person is also involved. They are a permanent resident of West Bengal. These two persons, Harudas and another Pavitra. They are permanent resident of West Bengal. They used to come at Port Blair, selling the cannabis to the concerned person. This Archana guy, she has a more than 6 cases pending against her.
Yes, take down. On secret information, the authorities, statutory authorities conducted a raid on the premises of
That conditions can always
Not to leave the silent
without the permission of the court,
all right, without, not to leave the island without prior permission.
subject to the satisfaction of learned CGM Maya Bandhan.
Maya Bandar.
Yes.
The order passed in his case. Same person. Separate person. No, it's, let it be 10,000 to sureties.
Let it be registered surety,
Registered sureties.
not to leave the islands.
You can't arrange a local surety.
No, it won't be possible, my lord. Registered sureties are there, advocates are there to, who acts as a registered surety, designated advocate.
There is a registered.
Yes, yes, my lord. There is a separate register maintained and the name of the advocates are there. Here also we have got the same thing.
Yes, registered surety and shall not leave the island without prior permission of the
Item number 2, Deputy 5 are granted a plea. Item number 3, APBT RCM 2 of 2024.
I will go the appellant. It is an application under section 37 of the Arbitration and Conciliation Act. Please. Lord, I just trouble my lord to kindly come to the award passed by the arbitrator. Which starts from 463,
463.
463.
Just give us a brief background. What is the-
This is a tender which was floated for construction of sea deck, 8 numbers of sea deck at Mangultan village.
Construction of?
Sea deck, my lord.
Sea deck.
Sea
Okay,
deck.
yes.
So during the, when the tender was floated, he has participated, the respondent has participated, he become as a successful bidder and the work was allotted to him. When he has visited the spot, he has to excavate earth because he has to pay royalty to the deputy commissioner for transportation of the earth. He has done, he has paid the royalty. When he has started to work, the forest department has raised objections saying that mangroves which are laying in the shore will be affected. So they raise certain objections. The work has not started. So then it was continued, my lord, and we issued under general
What
conditions.
was continued? If the work did not have
He has
started,
not been started.
then what
The deputy
continued?
commissioner, the tahsildar has been approached to conduct demarcations and they have been conducted a committee for demarcations. It is not, a fruitful result has not come on record. So thereafter, when my lord, we found that it is not possible for the contract to be concluded, then we issued a notice under 3A of the show cause notice has been issued under the general conditions of contract. As per general condition of a contract, 3A says if a person, if a contract, either liability of any of the parties, if it is not possible to conclude the contract, then they can determine the contract by issue notice. So cause was issued, he has supplied, the respondent has supplied a reply. They are not satisfied with the reply and the foreclosure notice has been issued.
So what show cause? What was the allegation against?
The
Showing cause-
allegation is that the work is not able to be completed, as such the show cause has been issued. My lord,
Where is 3 of the GCC?
yes, my lord. My lord, may kindly come to page number 65, my lord. Top it is 65 and inner it is 86. Right hand side top, my lord, it is 65. My lord. Inner it was 86. Lord, got it, my lord?
3 capital A.
Yes, my lord. Clause 3A. May I read, my lord?
Just a minute.
Yes.
So where is the question of issuing a show cause under 3A?
My lord, we have issued a show cause so that he can file reply. But as per this, we have to straight away issue foreclosure notice.
Yeah,
It is
so
not
there is
been.
no- that is why we wanted to see how can there be a show cause in a contract, yes.
No, 232 is the show cause notice, my lord.
No, but that is divorce the contract.
Yes, yes, my lord.
That is divorce the contract. And there is no dispute that the work could not commence
Yes,
because
even the arbitrator is also admitted in the award that he has not at the work, not started the work. The only ratio of loss and profit, because the arbitrator has come to the finding that there was a breach of contract by the.
so what is the date of the agreement?
Lord, it is at page number 25.
Can you give the date?
Yes, ma'am. Uh, this date of commencement is 1/12/2010, my lord.
And the date of completion?
Completion is 31st August 2011, my lord.
So clause 3A, if at all, was required to be invoked in January 2011 itself.
After a period of 9 months. Yes, my lord, as 1/8, so it should be in period of January. Yes,
In the January itself.
itself.
So neither parties invoked clause 3A in January.
January.
You also did not invoke in January.
We are willing to execute the order. So there are intentions were there.
That he has submitted. We are asking you a specific query. He is not saying that you were committing any default, you did not take steps. He says that mangroves were liable to be damaged. There was a serious objection by the
Forest
authorities.
department.
Work could not commence. They also realized it cannot be done. So they have called it off. But they have called it off whenever they finally wanted to give up.
Yes.
Whenever they wanted to give up. But clause 3A, you are a signatory to the contract. So from January, you had the option of coming out and taking your earnest money deposit and performance guarantee and everything. So why did you wait for 4 years?
That is, they have never said, that's why the documents.
What was not known?
They have never said that the work will not be executed.
3A requires them to say.
No, of course.
Read 3A. 3A requires them to say.
Clause 3 is also there.
Yes.
That they will terminate the contract if I don't execute.
So all right, that may be there. We are asking you, you had an option under 3 capital A to come out of it. On the completion of 1/8 period of the contract, you had the option of coming out. If you wanted to come out, you could have come out, taken your EMD, taken your performance guarantee, everything. You did not. You chose to stay for 4 years.
I do. That is the circumstances. That should be looked into.
Yes.
Or even payment submission.
So what prevented you from coming out of the contract in January 2011? What prevented you?
I have invested some huge amount, I have paid for performance guarantee, I have paid honest money deposit, performance guarantee for huge
All
amount.
these things you could have taken back. That is what we are saying.
But they have never said that the work will not be executed.
So are they required to say, is that a prerequisite to clause 3 capital A?
I'm a lowest bidder, I've been awarded the work.
That is not in dispute. That is not in dispute.
I work for profit and they have never disclosed. That's why I want to show the documents one by one.
First of all, we want to know what prevented you from coming out in January.
That's why I
So you exercised the option to take your chance.
to execute the work.
You did not want to come out. You are not worried about any loss.
Say no.
No, they are not required to say. Under 3A, nobody is required to say.
And all these problems has cropped up later. That's why the sequence of dates should be looked into. This forest and all, these are, but after the, by that time, 1/8 period is over. These all arising later.
Prior to that, nothing. So what were you doing for this period?
That's why, if, my lord, allow me to read the.
We'll come back to, yes.
My lord, I just trouble my lord to the arbitral award, my lord.
No, just a second. So when did you issue the note, show cause?
My lord, it is at page number 233 on 28th October 2011.
Page 233,
Yes, ma'am.
28th October
2011.
Yes.
I'm sorry, my lord. It is two, one page prior to that, my lord, that is 10th October 2011. my lord. 10th October,
232.
232, my lord.
Oh, this is three small a and b, not three capital A. We were just looking
No,
at
that
three
is
capital.
the clause, my lord. They have written in small a.
Clause 3 capital A.
There is no three A and B.
No,
There
no,
is
my
no
lord.
3 and
No small a and b.
So from where we have got three A and three B of the above agreement?
There is clause 3 has got 3 and clause 3. There is separate termination.
My lord, that is at page number 85 of the GCC, my lord will see 3A.
You have not given us page 85.
No, my lord, 64, my lord, top page 64. Not the pagation is run by the department, I'm sorry.
You have not given us.
Not 64, right hand side, top page.
No, sir, you have not given us. We have page 84.
Not prior to that, 3 capital A, my lord. Prior to 3 capital A.
It's not here. It is not here. This is 86. No, 84.
84, 84.
Oh. Paging is 85 is before 84.
I'm sorry, my lord, because it is done by the, I'm extremely sorry, my lord. I've done checked it. The two page numbers, my lord, that is a volume. There's an informal paper, but my lord, I'm extremely sorry.
You have given to both 85 pages to in the other paper book. You have not given page 85. So 3A and B are there also.
Yes, yes, sir.
That is why we were wondering how you could issue a show cause under 3 capital A. There is no provision there. 3A is the termination, so in that we must have issued.
It's for propose and termination. That is at the page 84, I think there's mark 63. Initially mark, it's the very initial. One contract can be determined. That is clause 3. And clause 3 is later. That is at page 65.
So what is the award? Let us see.
Yes.
Please, the basic facts are clear.
1 minute. Can show one paper.
Yes,
Page 79.
which 79 you are referring? This has two pagings, one in the center of the page, one on the right side.
One page is 79, one page is 227.
At the top, my lord, it is 227. Inner, it is 79.
What is the data date 4/4/2011? And just prior to that, another page. Back to that another page, then the letter, written to the Director of Agriculture. The demarcation was required.
Which is the earliest letter that you have written?
I have written the earlier, that is 13/1/2011. I'm just doing- So there, okay. Come to page 49. Then page 51. Then the next page.
Yes, what is the?
Then the next page, the individual rights to the deputy commissioner for issuance of permit. So these are required for execution of the work. Page 50. And a copy of, at the bottom, copy was also given to the. Just one.
Yes.
Then page 51. So I give you the page 51. Next letter, the Director Agriculture, whose project it is, the client department of APRD. He has recommended to the Deputy Commissioner for issuance of permit. Until unless they request, the Deputy Commissioner will not issue. Accordingly, letter was
Where is the award?
Yes. Sir. No, it starts 464 million. Lord, I take my lords the claim number 1, my lord, which is at page 478, my lord. Because these are the correspondence one which has been done. The final.
finding from 476. After recording the submission of both the parties.
476.
476. After submission of both the parties, claimant and respondent, the finding of the arbitrator is, so there is limitation point out. No? The 476, the conclusion of the finding of the arbitrator. They have raised the question of the enforceability of performance also.
The amount of performance guarantee is 67810.
Yes, sir. That has been released, but he has accepted. He is only claiming the interest part. Because the arbitrator has given 9% interest for 54 months.
Performance guarantee was 30,73,891. Against which
The 9% interest was levied.
No, performance guarantee. What was the,
that is the page.
It is at page number 478.
what is the amount?
That is, what you will find claim two.
Please give the amount. Tell us the amount.
30,73,891, 30,73,891.
Yes.
Which remain blocked from 23/11/10 to 24/3/2015.
This remain blocked. What?
From 23/11/2010
Till the date of closure.
24/3/2015 when they released.
Which date did they release?
24/3/2015. That is immediately after the foreclosure in 2015. One is unless one deposit. That is. 3,92,064. When block for 54 months.
So there is award in respect of interest. And there is an award with respect to the banking charges
That's the
for the preparation of
performance guarantee.
performance guarantee. And then there is loss of profit.
Yes, sir. Claim 6.
These are the three issues which have been quantified. Others are rejected. That means that you have been found at fault.
Yes, my lord. I just,
And for certain reasons, the other claims were not allowed because they were not appearing to be realistic to the arbitrator.
yes, my
Yes.
lord, my respectful submission before my lord will starts to the other claims. I just take my lord's to kind attention to claim number 7 once. My lord, the next page is the reason and award. 484, my lord, the inner page is 182. I just trouble my lords to the second paragraph. I have considered the defense of the respondent. What is found is that the work could not be started except the initial attempt of surveying. As discussed earlier, the respondents rightly pointed out that there is no record or compliance of procedure regarding hiring workers, bringing them from mainland. Similarly, there is no mobilization of tools, plants, and site, and also there is no evidence of construction of labor shed. Quite early, the objections were unknown, and I do not find any reason for the claimant to hire further resource on lease for the work, this work under the circumstances, as there is no conclusive evidence of unutilized resource block for the particular work. Hence, the considering the fact, this case, the evidence before me, the claim is not established. Not the loss of profit. First of all, I just with regard to claim number 1 and claim number 2, I have pointed out that the contract says under 3A. If
No, that you have not said. it. We'll see that.
yes, yes,
So first of all, you are on the issue of whether there is loss of profit.
yes,
You
I
say that there is variance in the arbitrator's findings in respect of loss. He said there is no material
Yes,
basis to
yes,
arrive at a
yes.
conclusion. Still, he has
said that
loss of profit is
issue you said 8% being a loss on profit. My respectful submission is when you are assessing a loss on profit, then you have to show you what are the investments he has done, because for that period how he has been idle, or that we have made ourselves make him to be idle for the particular project, due to that he is not able to do any other work, and he has sustained losses from that construction site. He has only the survey was done.
that is a separate heading. That is a claim number 7.
Yes, my lord.
Whether the two are severable or not.
Yes, my lord.
That is, you are saying they are unseverable.
Yes, yes, my lord.
They can only be decided together.
Yes, my lord.
The way one issue is decided, the other also has to be decided.
Decided. No, this is my submit when the arbitrator.
Then you should get some amount for this also.
No, because if that being so, when the arbitrator says that there was no materials or evidence, because my lord, he is the best person to judge the evidence and documents, my lord. Because when the
He has found that there is no movement of labor. There is nothing to
Lord,
show
when that
anything has been brought on this side. There is nothing to show that anything has been brought from outside the island. So therefore, he says there is no
investment has been done.
loss.
Yes. No investment has been done by the contractor towards this site. Only the survey has been done. And so along, he is also admitting that the site was never been handed over to me, never been handed over to me. Well, it is not an intention on the part of the authority saying that we are not able to give the site. We have given tender, we have been found to be eligible, we have showed the site. When there was please.
Yes.
May please. When that was when the survey was done, at the time it was found that the mangroves and the villages are raising objection because it damaged, the forest department has raised objection. Being that fact on record, my lord, the
6 and 7.
yes, my lord.
You are comparing the
Yes, yes, my lord. So this issue, the arbitrator's mind was that at least he should give some benefit on the count of loss and damages. But they should have judged the documents, what are the documents read by the other side, whether he has produced any document that he has invested this much of amount, he has been not able to do some other work due to the work which was executed in the present work. The loss and profit has to be assessed in all the materials, the arbitrator has not considered any materials. Rather, in claim 7, the arbitrator says no document on record by the claimant which has been produced before the arbitrator. Yes. Lord, I say 6. 6 is the award one, that is the loss and profit. 6 one. 6 has been
Or has been allowed?
6 has been allowed. The 7 has been rejected, my lord. And the reason for such rejection, which is at page number 484.
That loss of profit and damages
Yes, madam.
both are important.
Yes, madam. This is my first submission, my lord. With regard to the arbitrator, with regard to 3A. If my lord, I have already pointed out not the particular clause 3A, which clearly says either of parties, my lord, it is not reason has been given why it should be done under what circumstance it has to be. It is clearly says.
That you have correct.
Yes, yes,
You have
ma'am.
not specified that.
Specified.
But it specifies the time within which you can.
1/8, my lord. That I admit, my lord, because we issued 1/8, it has to be done. That what is a record, my lord, I cannot improve, but I admit that point, my lord, that 1/8 it has to be done. But when we have pre-closed.
Done or not done?
Yes, not done.
Either done or not.
I am. Lord, with regard to the claim number 1 and 2, Lord, I'm again, well, I'm troubling, Lord. The 1 and 2, I say, Lord, 3A, as Lord is absolutely right. 1/8, we have to do it on then, but we have not done it. But when we have issued foreclosure in 2015, immediately after that, the bank guarantee and the other amount, which is EMD, has been released. Thereafter, he changed the stand, Lord. Thereafter, he said that due to your fault only, I'm not able to start the work, and he has filed this statement of claim, and arbitrators were appointed after this order passed by this honorable court under section 11 of the. So, my lord, my respectful submission is the section 3A has never been considered by the arbitrator, and under section 34.
Arbitrator has considered.
But my lord,
He
the
has said
context.
that you are relying on PA
Yes, my lord.
to deny these things. That will be cutting both ways. You have also not taken action at the same time, so therefore now you cannot say.
Yes. Lord,
Yes, consider it's not that it's not. considered.
yes, even that reasoning that because free closure, we have not done within the time. So
Therefore, once that period lapses, you cannot rely on that clause.
this is my respect towards 3A, my lord, with regard to claim number 1 and 2. And I say this claim number 6 is absolutely perverse, my lord, because claim number 6 and claim number 7, the findings both are intercontractory with each other, my lord, because he says that the contractor sustained loss and profit due to the act on the part of the authorities. And as subsequently he has said, he is not able to show any document to show that he has started the work, he has invested, he has.
What has he said in section number 6?
But the issue number 6, I just take note the reason.
Just now said that he has said that he has sustained loss.
The loss and profit he has determined, saying that the due to the non-execution of work, he has sustained the loss.
Correct.
Under the section 73 of the contract act, the authorities are liable to pay compensation as a damage and loss and damages. My summation is when you have determined
Not damage, that is loss of
profit. I'm sorry, my lord, loss of,
notional, that is never actual.
yes, my lord.
Because the profit which he may be expected to earn, he has lost that. It is quantification of that particular aspect.
There is actual and tangible issue. Damages has to be specified with reference to.
Yes, my lord. My submission is that, my lord, I might be wrong, but my respectful submission before the honorable court is that, my lord, when the arbitrator, while considering the claim of loss and profit, should have determined the consequences, the documents which is to be produced, but nothing has been relied, my lord. He has admitted that no documents are produced by the claimant. And when claim number 7, it says that the work never been started and only the survey part has been done. Due to
No, how is it linked to starting of work? How is loss of profit linked to starting of work?
my lord,
That is not linked to starting of work.
but my lord, based on only an assumption saying that because
How is loss of profit according to you? How is loss of
but he
profit
has
to
to
be
show
around
it,
that?
my lord, that due to the non-execution of the work on the part of the authorities, I have been sustained loss. Because I'm not,
No, not I have sustained loss. I have not gained.
I have not,
It is a loss of profit. It is not a loss that he has to quantify. It is that if he had not been, his attention had not been diverted to this particular issue for 4 years, he could have utilized the overheads of his operation and his period to earn profit elsewhere. That has to be quantified.
my lord, that for elsewhere, if he has been not able to do it due to this, that has to be proved, my lord.
Therefore, we are asking you, according to you, what are the, give us two things that he was required to show for this. You say he has shown nothing. What do you think? According to you, what was he
No,
required?
it should have been shown with that, as my lord is saying, due to the present work, I am being idle, I am not able to do it any other works. So that's
No,
why
it is not any other works. See, a person may be doing 5 works.
yes, sir.
He has a 6th contract. The 6th contract does not go through. So that doesn't mean that he is already having 5 works, so he will not sustain a loss of profit. He could have taken a 6th work if his attention was not diverted here. If his overheads were not employed in this, that is a loss which has been quantified. It's not that he is required to show that he has not been able to work or anything like that.
No, once he says his site has not been done,
Therefore, it has nothing to do with the site.
the other part is also, my lord, the arbitrator has come with the percentage of 8%. That should be some logical conclusion. How for loss and profit.
For loss of profit, he has relied on the Hudson method.
No, that is
5%.
7.5%, 15%. That's an
5% and I want to there, my lord, attendant.
Yes, yes. Yes.
Yes, sir.
8%.
My lord, yes.
Show us where he has said 8%
Yes, my lord.
for loss of profit.
No, since the I just read 483, my lord.
Yeah.
Is not 8%. I consider as a 5% he has taken, my lord. I'm sorry, it is a 5%.
5%.
5%. Paragraph 1 to third paragraph, my lord.
Since the work could not be performed.
Basic cost of 80% of the contract, that is 5 crores 25 lakhs 53,173, on which the claimant have earned profit. Consider the fact of this case and that investment resources are hardly there. I consider 5% of 5 crores 22 lakhs 56,173, that is 26 lakhs 12,808 as a reasonable profit that should be allowed to the contract.
He has not given he has not considered the total contract amount. He has considered only.
Oh, really? Can you get the contract? Yeah.
Contract amount of 6 crore 14 lakh 77 crore. And we have considered reduced 15%. That was considered was profit. After that, only on that 5% is considered. What have you done? What he has done, the contract amount is 6 crore 14 lakh 77,827. And page 25, it is there in the agreement, page 25, why not, I just want to show it. Percentage on cost of materials and labor to overall overheads and profits is 15%, page 25. Page 25, it is 2x, at the bottom, definition 2x. It is 15%. So here deducted from the contract value, that 15% is deducted. And thereafter, on that sum of 5 crore 22 lakh, he has given 5%. It is not that the whole contract amount he has given. Consider. The contract amount is at page. Page 1 itself, contract amount is there. Page 1, contract amount is there on the top, standard amount. Is accepted. 6 crore 14 lakh 77,827. And he has considered at page 483, that is after deducting that 15, only around 85% of that contract amount. That is 5 crore 22 56 173. Fifteen has been deducted from second that part over which profit is deducted, and on that only, after the deduction only is allowed. Only 5%.
My lord, My lord, as my lord is saying, how to determine the loss and profit. Not the, I have made certain research. Lord, I've got a judgment which is recently passed by Honorable Supreme Court on 21st September 2023. My lord, I trouble to my lord, may kindly. My lord, it is 50 page. Yes, my lord, it is context of the loss of profit.
Context of an arbitral proceeding.
Yes, yes, my lord, absolutely right. Lord, I trouble my lords to, I'm giving copy to the other side. Actually. Para 23, my lord. The facts are, here part work has been executed and thereafter it is not able to execute. So, my lord, para 23 me once consider the principles. Lord, the
So in the context of the Hudson method.
yes, yes, my lord. Lord, the court has said.
That you are relying upon. There was already damages awarded. Therefore, the apex court said that it is over award of damages or double award. So when there is a basis, don't resort to the Hudson. When there is no basis, then you resort to Hudson. That is what it does. When there is no award on the ground of damages.
Not in
There
para.
was an award.
Yes, madam. Not in para 23.
Yes, para 23.
As Supreme Court has said, my lord, in order to determine the loss on profit, I might be wrong, lord, but I'm just
Yes.
pointing out, lord. Lord, has para 23, it says that a suffer arising from a depreciation of her his income from the job and hence turnover of the business also for the overhead in form of workplace extra which could have been deployed in other contracts. They claim to bear any persuasions before the arbitrator or court of the builder contractor has to prove that there was an other work available that he could have secured if not for the delay.
That was the facts of that.
By
case.
producing invitation, yes.
The damage was already awarded. You've already been awarded damages, now you are claiming loss of profit, so show us what profit you have lost. And in that context, as the court has said that the resort to the Hudson method may not be proper in this circumstance. Where actual damage has
Already been
quantified
assessed, yes.
on a real basis. That must be what you are trying to say.
Yes, yes, well,
The
this is-
entire facts have to be examined in totality.
yes.
Judgment, I have not read it.
Yes, yes, sorry. No, my respectful submission is, my lord, he is not able to show it or demonstrate. But that is one submission, and other is 3A has not been properly interpreted the arbitrator. And the honorable district judge under 34. I think this court, prior to this, the associate builders was the case wherein the honorable Supreme Court has imposed rider saying that 34 there are limited scope. Because the court cannot reappreciate the evidence also.
Talking to the point.
Yes, yes, absolutely right, Lord. But after this judgment, Lord, the even in para, this is as my Lord is saying that my Lord will kindly consider it. Para 31, 32, 33 up to 41. The Honorable Supreme Court has said under what protects the Honorable
31 to 41.
30 to 41, my Lord. Para 30 to 41, whereby the Honorable Supreme Court has opened a window saying that the court has a power to interfere under what circumstances a 34 can be entertained.
At variance with associated builders or signing of.
But associate builders also been quoted, my lord. Quoted, and it has been different. This saw pipe was the only judgment wherein it has been given certain scopes to interfere, and thereafter the associate builders.
Policy.
Yes, yes, my lord. The conflict with the policy.
By an amendment, it was brought out.
5 and 6 was inserted. Now public policy has been
Defined in this.
defined as shocking to the
Shocking to
conscience,
conscience.
not just a violation of the statute.
I understand, but because this is because this is the only judgment I could have find that the court can interpret as successful. Both the district judges not interfere with.
In fact, there the issue before the apex court, the court exercising jurisdiction under 34 had interfered by going into the issue as I could.
In this judgment, the Honorable High Court has interfered.
Oh, sorry, the division bench
Has interfered and section 37, they have set aside the award.
set aside,
Then the Honorable
saying
Supreme
that
Court.
there was a quantification of damages. Once that is done, this Hudson method, what are you doing? Why is this double award of the same facet? Or one award of the same facet?
I could have understand that the Hudson method is not correct because it should be a sum.
That you are saying relying on para 23, that we understood.
This is my respectful submission, madam.
Before the run the arbitrators paid 105 to 100.
No, we will hear
Balance
you,
sheets have also.
we will not hear you today. I want to see this judgment. Once your argument is complete, we will.
Yes, yes, ma'am.
So mainly your thrust of your submission is 3A not considered,
Yes, ma'am.
and there cannot be a variance in the finding on issue number 6 and 7.
This is
Once 7 has not been held to be
valid because his claim was rejected. Then how come?
and thirdly, in respect of issue 6, you say that the calculation also is
Not any basis, ma'am, without any basis.
without any basis whatsoever,
Yes.
in a way.
This is my.
These are the
These
three
are the-
submissions. It is submitted by the learned counsel for the appellant, referring to decision of unreported decision of the apex court in the case of Batley environmental engineers, civil appeal number so and so, that the tribunal
Any mentioning not in the list? Any mentioning in the list? Item number on WPS 637 of 2024.
Compilation. Forty-two, 1942, pre-42, and 61 survey was conducted.
On 61, the survey was.
Yes. On basis of that survey, this policy decision was taken between July 2003, where it was excess land will be required from the extent, but concern applicants are.
July 2003.
So.
But where is the policy of 15 July 2000?
Policy as such, the ministry has taken decision, your lordship, if your lordship can see the very first line.
And this-
Just let us.
These are the guidelines.
Just wait. The investment of the limitation.
1965.
All those who are claiming to be 342 settlers, they have to claim only to these 438 number of
Family.
families, original occupiers.
And then descendants.
And obviously, so from these 438 occupiers, only through them a claim can be made.
And the private installment is also there. So please, 51 service, in 51 service. I think it's there. And like I said, he has submitted that she got married in 1966. And this survey was conducted prior to 62. So, and on that basis, the list of encroachers has to be, if I not see the list of encroachers, the cases recommended for regularization, if abetting village. Serial number thereafter, name of the tenant as per 1961 survey.
Yeah.
So, serial number 90. The name of the petitioner is mentioned. Calcutta, Harinara, Gujarati. All the legal errors of Mutila. 90. Serial number 90.
Is there not?
The other time a letter was submitted that he has changed the name. Hriday Narayan. And then he made an affidavit that actually my name is Hriday Narayan.
And if fellow sees the repetition, it is Motira. So he has to write whether it's father's
You
name.
have also changed the
Yes.
father's name.
No.
Motira.
Actual name is Moti Ram. Wrongly recorded in the recommendation.
It's a different person.
This list is sacrosanct.
But this is the internal thing. I am not aware of that list.
You are 101% aware
Yes.
because the survey was conducted.
Report sent, ministry did not accept. It said you confirm it. It was published for public consumption.
No, that.
Objections. Oh, yes, it was. Objections were invited. There were objections. Some accepted, most rejected. Thereafter, the original list which they had recommended of 424, some were added on objection and then finalized at 438. Nobody can say that I am not aware of this list. There is no scope for saying that. The law does not permit. It is published for wide consumption, objections invited, all done. So you cannot say you don't know.
Let them serve a copy of that report so that
Not required, sir.
the exception of that report.
There is no
Directly
report.
done or not.
There is no report. There is no report. This is a public document. This is not something which they are doing for this case. This is a public document.
Not denying. They are producing certain documents.
They are not producing any document. This is a public document. This is in the public domain. Anyone can read it. If they rely on section 6 of the Specific Relief Act, are they required to serve a copy of the gazette notification of the section? You go and examine it. Who is stopping you?
And then after he made an application for correction of his name.
Yes.
At that time also he has not raised any objection regarding
He has applied for correction of this
his name, of his name.
in this record. And he is saying he does not know about it. And you are saying you don't know about it. Very peculiar.
No. That report. I know about the license.
Very peculiar
When I
submission.
found that license is name of my.
Yes,
name
where is that
directly recorded.
application he has made for? You don't know about this. You don't know about this document.
About the recommendation.
You don't know. Come to page 22, what you have written from paragraph 6 onwards. Don't make submissions contrary to record. The other day also I told you, don't make submission contrary to record. You have written this.
Yes,
You know everything, 2003, 2008, everything. And just now you said, I don't know.
no, I don't know about the document which.
Then how are you saying about the document? Come to page 23. License dated 23/12/2008. Everything you
I
know.
have stated that.
You have stated everything.
Yes.
Don't make submissions which are not born
I
from the
know
record.
these.
Don't-
Representation for correction of the name.
Yes, in this only. And you are saying you don't know. Very peculiar submission.
My lord, I never said I don't know.
You said that they must have a copy. I don't know about this.
No, whatever.
That was the initial submission you pick up without even referring
What
to.
are the document they are producing, showing today, that I don't know.
This is the document which you are, the correction of which you are seeking. It is that document.
Yes.
Why this is not in publication? No, is it? Huh?
Widely circulated.
No, this letter of 29/10/2008. It is available in the public domain. This list should be, it is a government document in public domain. No, this compilation. It is there. He has made an application for correction of this. Yes. He makes such submission. So you are claiming to be this Hari Narayan. You are claiming to be this Hari Narayan, who has been stated here. But you are claiming to be Hari Narayan, son of Motilal, who is not Motilal. You are claiming to be Hari Narayan, son of Motilal, who is not Motilal. Very unique claim, sir.
Actual name of my client is Hriday Narayan. It is
And
wrongly.
name of your client's father is also different.
Yes, Motilal.
Yes,
But it is wrongly recorded.
wrongly recorded.
So I made representation to correct.
Very good, very nice.
It's Motila, so there is Motila. On affidavit is Motila. And if you cannot see the content, this is para number 2. The father of the petitioner may be Motilal. Was in pre-1942 zero of these islands.
And the land is also the same 2317 of 2002. 2317/2. Same land. He knows every detail from this.
Yes.
He knows every detail from this.
This was published in this.
So this was the correction was rejected. Plea
No.
for correction was rejected.
No, it was allowed.
It was allowed.
Allowed.
And your name was the name.
Corrected. In the
Where is that?
my lord.
Page 18. And it should see.
But you have allowed the change. That is not son of, that is not son of. No, but you are showing that the survey plot number against his name is the same, 2317/2. So there is. How could you have corrected? How could you have corrected when he is claiming to be son of a Moti Ram? Then how could you have corrected? What is the procedure for correction of this name? That's all.
No, my lord, there is a provision under section 87 of the regulation 19.
Must be, that's why we are asking.
Provision is
87.
87. 87 and 87.
In respect of pre-42 settlers also.
All,
Anybody.
anybody.
So there was an admission on the part of Ganga Charan and Puja Devi also, given for his name.
But he was not never contacted to.
Then how it was the change was allowed? Regulation 87 says the deputy commissioner may anytime correct or cause to be corrected any clerical errors and any errors which the parties interested admit to have made in the record of rights. So parties admit, not the party applying. And who are the parties? The interested parties. So all these three will be interested parties. So without the consent of other two, how it could have been corrected? Who has issued this order? Is by which authority?
Deputy Commissioner.
Very unique. What is the date of this correction? 5/9/24.
Not appearing from this. Or.
So you ask for the records. Ask him to show how it was, how the correction was done and under which procedure it was done. So after this correction, now what you are seeking?
The issue here, my lord, because the scheme says.
So now first you get your name corrected and then you want deletion of.
Yes.
And then at this instance, she is noticed. That has been rejected.
My application, no, it is pending. The representation is still pending. Page number 20, it is still pending representation.
So you have conceded to his name being corrected.
That would be informed by the other, but it will be informed for correction.
Have you filed an opposition?
You know, we
Yes,
get
sir.
it.
What have you said about his correction?
Nothing.
Yes, he has brought on record the order of correction. He must have stated.
Right, that's true. Saying is denied for want of specific knowledge.
Paragraph 9. In the present writ application. First week on that has. We got a copy of this one.
Item number two, year 50 and up, 924.
On the last occasion, substantial hearing was done. Now, this is that matter where a trial court grants mandatory injunction. The very frame of the suit is a suit in simpliciter seeking protection based on possession, suit seeking permanent injunction. An interlocutory application was taken up. The trial court directs my client being the defendant to put plaintiff into possession. Worship, if the plaintiff, look, the frame on the suit is very bad in law, not. At best, section 6 of suit could have been maintained. Restoration of, they filed a suit for permanent injunction. They claim that they have been dispossessed prior to the date of filing of the suit. And the court, in a very casual manner, lordship, as if it is an application under order 39, 1 and 2. No. Appeal was carried and order of affirmation is also there. I'll take notice of the trial court's order. But immediately after, not to find, I have not paginated it. Immediately after page 111 of the trial court's order. An order dated not 30th of October 2024. Passed by the trial court, Civil Justice Senior Division 4. May I place your? No. That's a 1990 law. Yes, ma'am.
117.
Yes, ma'am. Yes, ma'am. And the relevant paragraph would be below. I'll just draw below to paragraph 16. The standard of satisfaction, my lordship, as compared to a prohibitory injunction or order 13 and rule 1 and 2 is more insofar as mandatory injunction is a concern, my lord. Several things needs to be gone into the trial court in a very casual manner, as if it's an application that order 13 and rule 1 and 2 has direct my client to put plaintiff into possession, whereas the plain case runs with these facts that the plaintiff is in possession, a decree of permanent injunction has been sought for. No, that's not there. No, when the suit was filed, an application under order 13 and rule 1 and 2 was filed, whereby the plaintiff at the first instance sought a direction upon my client not to create a third party interest, thereby admitting my possession of the technical suit property. That application was not trust. Then the second application, the first one which was moved on the very date when the suit was filed, there they have simply sought, I'll show that application. Lord. Now kindly turns to FIR has been lodged against me for trespass. Now page 36. Page 36 of the application, annexure P3 collectively. Now see page 36.
Yeah.
Now it's an application under order 39 rule 1 and 2. It was filed on the very same day when the suit was filed on 2810. Now kindly see the prayer at page 41. They have admitted my possession which was done prior to filing of the suit. That's on 25/10/2024. They simply sought a prayer before the court below. It is humbly therefore paid that the honorable pleased to pass an ad interim order directing the defendant not to create a third party interest in the said shop room and pass an order of injunction restraining the defendant from creating a third party interest till the disposal of suit. Thereby admitted my possession.
What is the date of filing of the suit?
Suit is 28/10/2024.
29 they had used.
And on the way 2810 it's moved, it was not pressed, and on 29th, that's on the following day, again a mandatory
Not pressed on 29.
29th. And on the very same day, a mandatory injunction application is done. The color of the prayer has been totally changed. I'll just show that now. The second application at page 51 on 2910. Page 56, the prayer. Look, the tenancy rather lapsed in the month of May 2024. The tenancy was surrendered. What prevailed in the mind of plaintiff lordship? She filed a suit on 2810. So leaving aside ifs and buts, lordship, the fact remains the day when the suit was filed, the plaintiff was not in possession. If that be the case, the very suit is not maintainable. If the very suit is not maintainable, no interlocutory order in any form, be it in the form of prohibitory injunction or order 13 rule 1 and 2 or mandatory injunction under section 37 specific can be passed. The frame is bad, lordship. The very frame of the suit is bad. But I could have understand, Lord, that when the suit was moved, there is a status quo operating the field as regard possession. Even that order, my Lord Supreme Court has deprecated. Status quo order, it's a meaningless order. First, it has to be ascertained who is in possession, then the status quo order. Either one has to be restrained or it has to be rejected. Even worst to worst situation comes in, my Lordship, status quo is prevailing, plaintiff's possession was disturbed. In such a case, subject to the satisfaction of the court below, the mandatory could have been directed. There is no status quo operating in the entire affairs. Whether it's an illegal eviction, whether the tenancy was surrendered, it's all done prior to the filing of the suit. It's on 2510. It's a specific case. Even in the plain they have admitted, Lordship, that I've taken possession of the suit land. Allowing a mandatory injunction, Lordship, tantamounts to deciding the suit in a pre-trial stage. Because if the plaintiff is put back into the possession of the suit land, that would one way legalize the claim as made in the plaint. This is not a fit case, I would say, where the trial court could have exercised this discretion. Because degree of satisfaction plays a predominant role, Lordship.
Satisfaction as to existence of what affairs?
Lordship, because who was actually in the possession? The day when the application was moved.
Correct. So that is the most important.
Absolutely, absolutely.
The degree of satisfaction will come later, because there has to be a pleading as to existence of that state of affairs
I'm grateful.
on the date of filing of the suit.
I'm grateful.
Only thereafter
They've admitted in the plaint.
the degree of satisfaction will come.
My lord, they've admitted in the plaint. Paragraph 29 of the plaint, my lord, even on the last occasion, they've admitted that the defendant has taken possession.
The apex court has used the expression the last uncontested status
Yes, my lord.
preceding the filing of the suit or at the time of filing of the suit.
Kishore Khaitan's case, my lordship.
In this case itself,
But-
I'm trying to look for that.
By Justice S.V. Sinha was one of
No, in this case,
Yes, my lord, yes.
for grant of
Yes,
mandatory
yes, my lord,
injunction,
yes, my lord.
temporary mandate, that it has to. The existence of the last uncontested status,
My lord,
which is to be preserved or restored,
my lord,
either way.
my lord.
Here, the uncontested status is that they were already deprived of their possessory
Possession.
right.
My lord.
There is no contest on that. They could have said that we are still in possession.
Yes, my lord.
If they had said that, then it may have been a different thing.
My lord.
No, my lord. Up to 23rd of this October, my client was in position.
Correct. That's what he is also submitting.
Yeah.
He's not don't say no, say yes. He is also saying that.
The application moved on 28th October.
Therefore, on 28th, you were not in possession.
No, before that, after the next day, 24th October, my client is sent one legal notice to come forward and review the agreement, tenant agreement, this rent agreement. And he has, by force he has sent and he has refused. Then the next day on 25th of October, midnight, the landlord had come with some, his party, some another people and forcibly broken the padlock, opened that this one, the shutter and thrown the articles from the shop without the information, without the knowing of my tenant. The next day morning only he knew. Then he went to the this police station Aberdeen and filed a application, this complaint application, then FIR lost.
What
After
was that?
After that, all the
Two FIRs has been lost. What is the number of the first FIR?
it was on 26th May.
I've seen the date. I'm asking you the number. One is on the date you allege that you have been illegally thrown out. The other is when you objected, they have beaten you.
Yes, madam.
There are two FIRs. So give the number of the two FIRs.
Yes.
What is the police station under which this property comes? Which police station?
This is Aberdeen Police.
So it should be Aberdeen PS case number something.
This is on 26. Number is FIR number is 0180.
0180.
Yeah.
This is under sections.
324/4, allowed, and 331/4.
And the second FIR? This is, sorry, this is of which date? 26.
On 26.
And the second one?
Only. And that is a 0181 on 27/10/2024. It's under section 115.2, page number 16.
Page number?
16 from 16.
And the suit was filed on 28th.
On 27.
Suit.
Suit and 20.
We will proceed.
It's CO 51 of serial number 51 of 2024.
Yes, you are also relying on some judgment.
Actually, my lord, actually, this matter already has been decided. Section 11 of CPC, get the present appeal because the matter already been decided by the High Court, bench at Port Blair. And this is totally, there is complete violation of Article 21 of Constitution of India, my lord. I have to give relief, my lord. As soon as possible, the matter may be decided. Yeah, on merit and natural justice, my lord.
Section 11.
Yeah, this is section 11 CPC, hit the present appeal because the matter already been decided by the Honorable High Court at bench at Calcutta.
What has happened, trial court order was stayed or still before this court. Your Lordship, page 81, initially the entire proceeding was stayed. Then other side mentioned that the order being an appealable order, I cannot assail in civil division. Then this court at page 84 granted me liberty to approach the first appellate court, being the district judge. District judge was approached, order of affirmation. So these order of the trial court as well as the order of the district are under challenge.
Where are those two?
Not page 81 by this court.
What
Election
is that?
letter
Why-
T5.
How section 11 is applicable?
The matter has been decided, my lord. The Honorable High Court Calcutta.
Where is that decision?
The High Court given the direction, my lord, as per the district, Honorable District Judge. and-
Show the order. How many times you will say the same thing decided by High Court given the direction? Show the order.
That CO 43 2024.
12-11-24 order. 12-11-24 order. All right. So section 11 with reference to 12-11. Yes, anything else? Yes.
Yes, my lord, we are suffering there, my lord, in this matter. Kindly decide, we are suffering due to non-defense of the suit are getting huge loss and market in terms in money as well as the reputation which cannot be compensated in terms of money at all. So kindly decide the matter on merit as soon as possible and the natural justice.
Kindly decide the matter as soon as possible. We are hearing you on the final. What do you?
I praise kindly decide the matter.
So what are we doing? What am I doing? What am I doing? Yes, paragraph 16 of that judgment. No, that I was looking for that expression. You read paragraph 16, the very first sentence. Yes.
Mandatory injunction are first granted generally to preserve.
To do what? Preserve or restore the status quo of the last non-contested status. This is the position that's first. It has been quoted in a subsequent judgment.
So, good morning.
Yes. I'll pass the order. The parties have made their submission. I want to go through all the petitions which are on record. Mr. Saval.
Item number 3. WPS 3 on 7 of 2020.
Not today. And appears on behalf of the petitioner. The matter stands adjourned for the day.
Item number 4. WPA 593 of 2023.
I'll file a slide to the, just some time.
How much time?
I appear for response number 1.
10 days. The petitioner's counsel seeks time for filing a reply to the affidavit in opposition. Stop, it is submitted. He requires 10 days to stop. List in the next available circuit. Let the reply be filed in the meantime. Yes.
Item number 5. WPA 302 of 2023.
Not true. Same. Same order.
I appear for response number 1, 2 and 3, my lord.
Yes.
Item number 6. WPA 100 of 2023 with item number 7, 8, 9, 10.
I am for responding 7, 9 and 10.
They have to file the motion.
In all these matters,
It's an analytical.
there is a direction for filing opposition. That has not been filed in any of these matters.
Not filed, my lord.
File it,
Please
we
speak.
keep it in the next week, you file
My
it.
lord.
There is an order earlier for filing opposition in all these matters. No, whether there is an order or not.
We'll file.
They've been taking time.
By way of last indulgence. By way of last indulgence. The respondents' counsels are allow time till, give date of Wednesday for filing affidavit in opposition. List these matters on Friday, give the date of Friday.
Highly obliged, my lord.
Number 11. WPA 111/24.
And for the official respondents.
There is a private respondent also. They are in appearance. There is a name of another counsel appearing on the respondent side, that is why. Yes, somebody is appearing for the private respondent.
And for 1, 2, and 3.
You have not filed a opposition. Anyway, let us see. What is the issue?
My father's property, without any notice to me, nothing, lordship, without any proceeding under the local regulation, has been given to the private respondents. But these issues were agitated by me since for a long period. I've been making representations, lordship. And finally, when the representations were not considered, lordship, the writ court was approved. Finally, Deputy Commissioner passes an order at page 52. Page 52, and this order was again exhaled before this court, and this court at page 56 set aside the order and remanded the matter before the Deputy Commissioner for fresh consideration.
Page 75 is the audit, which is under challenge.
Why don't you just have someone intimate the private respondents? His name is already appearing. Let him be here, inform him. I'll just adjourn it, not today. It will be not today, let it come on, yes. The name of Leonard Counsel is appearing on behalf of the private respondent, full stop. The Leonard Counsel, however, is not present, full stop. The appearing counsels are requested to inform him regarding the matter being taken up on Monday, the date of.
Okay.
Item 12. Here on of 23.
My lord, in this matter, Mr. Arun S. Kumar is appearing, service not completed, my lord.
You are for the respondent.
Petitioner, appellant, on behalf of the appellant. Arun S. Kumar is for the appellant.
Where is he?
He is on another court, my lord.
All right, not today. Let him be here.
Obliged.
Number 13. Here copy of 23.
And in this matter, we are for the Union of India. The petitioner is not appearing for a long duration of time. If you lordship will see the last orders.
Let's see. Who is for the OP number 2?
But he appearing for.
Through virtual mode. He has filed his statement on affidavit.
Pardon, Your Lordship, I'm appearing in the virtual board for opposite number 2 for SN Kanungo.
Yes, why have you not complied with the last order?
Lordship, I have already filed the affidavit.
You have.
Yes, yes, yes.
Between the petitioner and the opposite party.
What is the case about?
They are challenged the arbitration award. And Union of India has nothing to do, but I don't know why they have made us a party in this matter.
You are the private respondent.
No, he is appearing for the private respondent through VC, my lord. Mr.
And who is the petitioner?
Petitioner is, my lord, from long duration of time is not appearing. In fact, on last circuit, Mr. Tapan Das appeared for the petitioner and he said that he is recusing himself from appearing for the petitioner because petitioner is constantly not giving any instruction to him.
Pardon your lordship, may I submit with your kind permission? Madam?
Yes.
Lordship, I am appearing for the private respondent too. Actually, lordship, this award has been challenged for, this award was passed in the year 2008. So in 2008, it was between SN Kanungo and Union of India. This award relates to an agreement for the extension of the runway work. So the runway, the Port Blair runway,
Yes.
in the year 1995 to 1996. So this award arises of that agreement in which the private respondent, who is SN Kanungo, who passed away in the year 2012. So the award holder was SN Kanungo. In the so after the award was finished and when the SN Kanungo filed for execution, the petitioner themselves claimed as the interveners and the legal representative of the petitioners, say the legal assignees of the petitioners, claiming that they are also the part of the agreement, in which learned district court dismissed their appeal. Then learned High Court, Honorable High Court also dismissed their appeal. Then Honorable Supreme Court also said that they are not the intervener assigners, but the only thing was to be tried by the learned district court was the check and the deed of assignment, in which they were claiming merely after 15 years. So Honorable District Court also rejected their plea. The trial was conducted. They did not prove the check or deed of assignment. They failed to prove and it was a false and signature by the petitioners. So the award holder, Mr. S.N. Kanungo, the legal heads of the award holder has already withdrawn the money. And from last 1 year, they have filed this petition just to harass the award holder, and they're not even appearing. So on the last occasion, the advocate for the petitioner, he withdrew from the case, stating that he will not anymore contest or appear for the petitioners. So on the last occasion, Honorable Justice said that to file an affidavit claiming that the matter has become influential and that the amount has already been withdrawn. So an order can be passed for non-prosecution.
None of
So this is the
of the petitioner. Wednesday.
Lordship, actually, the order was not communicated. I was paused in between by the host.
Come on Wednesday.
Obliged.